and let me say what an honour it is to be on this panel with such incredible lawyers who have made such a huge difference in the use of law to advance human rights, peace, justice and disarmament. I'm one of the non-lawyers that Peter Weiss was talking about who got inspired to become engaged in law because as a political activist from New Zealand working on nuclear abolition issues, I could see how valuable law could be to assist political process. And so I got involved in the World Court Project, and I'll give a little bit of an overview of what that was. So what I'm going to be talking about in this presentation is the World Court Project on nuclear weapons and international law, which was the civil society campaign to help get the case to the court, then to work with the lawyers and the government to win the case, and then to follow up after the decision from the court on implementing the decision. So I'm going to talk briefly about those three things. In the interest of time, I'll have to go a little faster through some of this and leave a couple of things out. There's a lot more to the story than I've got time to fit in 8 minutes. But getting to the court first, the origins. So this probably dates back to when nuclear weapons were first used against Hiroshima and Nagasaki, and the illegality of them, as written in Jackie Cabasso's article, nuclear weapons have always been illegal and in violation of the law. But how to bring that into reality? This is why legal opinions is very important. And the Shaw McBride appeal, getting 11,000 lawyers to endorse the argument that the threat or use of nuclear weapons is illegal, was an incredible development. So too was the London Nuclear Warfare Tribunal in 1985, which was like a mock case of putting nuclear weapons on trial. This all helped many other things, and I can't go through them all, to build up the legal arguments and also the understanding that the legal arguments against nuclear weapons are very strong, which could give rise to taking the issue to the International Court of Justice. And the idea and advisory opinion actually came from the Lawyers' Committee on Nuclear Policy and then ILANA. And there had been a few attempts in the 1980s to encourage governments, but none of them had picked up that idea and introduced a resolution at the General Assembly or somewhere else to take the case. What stimulated it was the dispute between the United States and New Zealand, my country, when we decided that we're an ally of the United States under an agreement, a military arrangement, ANZUS treaty, and we decided we wanted to ban nuclear weapons, which included not allowing US nuclear warships into our harbours. The United States opposed this, said we couldn't do it under the ANZUS treaty, and we were looking at how to keep our policy and turn it into a sustainable legislation. And we had the suggestion from Richard Falk, who was a board member of the Lawyers' Committee on Nuclear Policy, that maybe New Zealand should look at taking this case to the International Court of Justice through an advisory opinion approach. We took this to David Longley, the Prime Minister, and he said, look, it would just be politically suicide. At the moment, we're struggling to survive, and all we're doing is saying that we're banning nuclear weapons from our own country. To take this into the international stage would be too much. You need to build up support from other countries for New Zealand to come on board. So that stimulated Harold Evans, a lawyer, Kate Jews, who was Vice President of the International Peace Bureau, and Eric Geiringer from International Physicians for the Prevention of Nuclear War, to suggest to those organisations to propose that they come together to form the World Court Project so that there'll be a big civil society campaign to help build support from the governments. And it was launched in 1992, the World Court Project. More background is in those couple of books, that I've put on here, if you're interested in reading some more of the background to it. So once there was a decision, yes, civil society wants to support lawyers in getting this case to the court, is how do you get there? We looked at three different bodies, UNICEF, the World Health Organization, and the UN General Assembly, and basically took the initiative to both the World Health Organization and the UN General Assembly. And then in terms of building civil society support, we invited organisations around the world to join the campaign. Over 700 joined, and then those organisations were instrumental when we had the resolutions in the World Health Assembly and in the UN General Assembly. We called on them to encourage their governments to support. In addition to that, we engage citizens with something called declarations of public conscience. There are over 4 million of them signed. Here we see boxes of them being presented in front of the court by one of the leaders of this initiative, George Fairbrother. So very quickly, the World Health Assembly request, and I pay a tribute here to Hilda Leni, who was the Minister of Health of Vanuatu, who was one of the leaders of getting this successful resolution adopted by the World Health Assembly in 1993, taking the question of the use of nuclear weapons to the International Court of Justice. Unfortunately, the court turned down that request, saying it wasn't in the mandate of the World Health Organization to ask a legal question about nuclear weapons. But that was really important because the World Health request meant that a lot of evidence was presented to the judges anyway, and that was very, very helpful in the case which did proceed, which was on the UN General Assembly. And Hilda sent a message here for this event today, the 25th anniversary. I don't have time to read it out, unfortunately, but we can make it available afterwards. So the UNGA was important to get through. It came after the World Health Assembly. It was important. If we'd only relied on the World Health Assembly, we would have lost the case. So the UN General Assembly was very, very important. In order to succeed, it was tough. We had to set up a hub at the UN, and the Lawyers Committee on Nuclear Policy served as the hub to monitor what was happening, to work with the delegations to the UN on draft resolution, and then to feed back to the supporting organisations around the world progress reports. But just as important was lobbying in the capitals. We wouldn't have got the governments to support if we'd only talked to the ambassadors in New York or their ambassadors in Geneva. So I spent a lot of time flying around the world, going to both capitals and to heads of state meetings, Non-Aligned Movement, Pacific Islands Forum, etc. We lost the first year. Even though we had the Non-Aligned Movement on board, the lobbying power of the nuclear-armed states was so powerful that they got the Non-Aligned Movement to withdraw the resolution. We came back strengthened the second year and got it through in 1994. It was a huge campaign, a lot of work, but we managed to get it through. The next part is actually winning the case. I'm not going to spend much time on this, but there's 3 key factors to ensure that you do win the case. One, the law, of course, the most important, and having the legal experts was vital. And Iolana provided legal expertise, which many governments use. So too important is the facts and the evidence, because the court applies the law to the facts and the evidence. So there are many ways that we were getting evidence of the impact of low-yield nuclear weapons would still be indiscriminate, for example. The long-term effect of nuclear weapons, which really came from the impact of the nuclear testing, witnesses from the Pacific, which was very important on the nuclear testing. And I think it was a testimony of the Marshall Islands, which brought about, the affirmation of the court that the destructive power of nuclear weapons cannot be contained in either space or time, which I think is one of the most important parts of the court. The third part is political framing. And that was really important to ensure that the judges would perceive this as an important issue, and that the abolition of nuclear weapons, the prohibition, was something which majority of countries around the world supported. So we had to make sure we got a lot of countries to put written submissions into the court and turn up to the oral hearings. And one of the things with the oral hearings was we wanted to make sure we had the last word. And we had problems because when the list of countries for the oral hearings came out, the last 2 countries that were going to present, which would give a lasting impact on the court, was the UK and the USA. So we had less than 2 weeks to find a country in the alphabet that came after, which we did. We got them into court and we managed to have our opinion as the last opinion in the oral hearings, which I think had some impact as well. Finally, on implementing the decision, and I'll be very, very brief because I think I've nearly used up my 8 minutes. The court's advisory opinion is not necessarily self-implementing. Now, it may have some direct impact, and we did see some governments, the UK and Russia in particular, change their policies after the decision of the court. Russia adopted the language from the decision from the court restricting threat or use of nuclear weapons to cases of extreme circumstance, the self-defense, when the survival of a state was at stake. So there was some shift there. UK made 3 initiatives. I won't get into it at the moment. They've now gone backwards. But immediately after, there was some impact. But it actually takes more than that, and that's why we worked on the follow-up UN General Assembly resolution, which called for implementation of the decision by having negotiations for a nuclear weapons convention, which would provide for the complete elimination of nuclear weapons under strict and effective international control. We followed up with the NPT Review Conference, particularly through our partnership with the New Agenda Coalition, and that was very successful in getting the 13 practical steps for disarmament agreed in 2000 at the NPT. And then there are other ways that it was used in domestic court cases successfully, like the UK Trident Ploughshares, where they got acquitted based on the decision from the court, and the Citizens Weapons Inspection Teams, which is a public action to follow up, which was quite inspiring and fun. And that was inspired not just by the ICJ opinion, but also UNSCOM. And so Citizens Weapons Inspectors went to nuclear weapons facilities in nuclear armed and allied countries in order to monitor the compliance or report non-compliance with this law affirmed by the International Court of Justice prohibiting nuclear weapons. There's just a few photos of the Citizens Weapons Inspectors. And then I'll finish with the inspiration now, which is that this case has given inspiration to youth around the world to launch a campaign to take the issue of climate to the International Court of Justice, and we're serving as advisors for that. Thank you very much.
Well,